Hello everyone. On August 11th, the Home Minister introduced three bills: Bharatiya Nyaya Sanhita Bill, Bharatiya Nagarik Suraksha Bill, and Bharatiya Sakshya Bill in the Loksabha, replacing the Indian Penal Code 1860, Criminal Procedure Code 1973, and the Indian Evidence Act 1872, respectively, and these were referred to the Standing Committee on Home Affairs to carry out consultations and submit its report. According to the government, the bills were aimed at decolonizing the Indian justice system, as these acts were made to strengthen and protect the British rule, and the purpose was to punish and not to give justice. Changes are stated to have been brought in these fundamental aspects. In the last 14 presentations, the provisions in general part of the Indian Penal Code from sections 1 to 120b and section 511 containing the principles of criminal liability have been dealt with in detail. It would be appropriate to know what the position of these provisions would be in the proposed Bharatiya Nyaya Sanhita. In this presentation, the changes that are proposed in sections 1 to 120b and section 511 of the Indian Penal Code would be explained. The remaining aspects would be explained as and when specific offences are taken up. The Bharatiya Nyaya Sanhita 2023 is proposed to be enacted with an intent to consolidate and amend the provisions relating to offences and for matters connected therewith. The general part consists of principles of criminal liability. This is contained in chapters 1 to 4 running from sections 1 to 62. The specific offences are contained in chapters 5 to 19 running from sections 63 to 356 of the Samhita. Subsections 1 to 5 of section 1 of the Samhita contain the content of sections 1 to 5 of the Indian Penal Code verbatim. However, Clause 3, which was added to Section 4 of IPC in 2008, according to which the provisions of the code will apply to any person in any place without and beyond India committing offence targeting a computer resource located in India, has not been included in the Sanhita. Explanation B attached to Section 4 of IPC, which provides that the expression computer resource would have the same meaning as assigned to the term in the Information Technology Act 2000, has also not been included. The general explanations, that is chapter 2 of the Indian Penal Code running from section 6 to 52a, contain the explanations of various terms and expressions used in the code. Chapter 2 of the Indian Penal Code has been reduced to one section, that is section 2, consisting of subsections 1 to 39, which explain the various terms used in the Samhita. However, section 6, which is the key to the general exceptions chapter, section 7, which states that a term once explained in any part of the code should be understood in the same sense when used in any other part of the code, section 27, which states that the property in possession of the clerk, servant or wife of any person is deemed to be in that person's possession, and sections 34 to 38, which provide principles and rules pertaining to joint liability, are contained in section 3 of the Sanhita. The provisions pertaining to punishments, which are contained in chapter 3 of the Indian Penal Code from sections 53 to 75, are included under chapter 2, consisting of sections 4 to 13 of the Sanhita, that is, the new penal law of the country. There is no change in any aspect except for the inclusion of community service as a kind of punishment that can be inflicted for the offences under the Sanhita. The general exceptions contained in sections 76 to 106 of chapter 4 of the Indian Penal Code have been included in chapter 3, running from sections 14 to 44 of the new code. There is no change in the content of any of the provisions. In the Indian Penal Code, provisions pertaining to abetment are contained in chapter 5, from sections 107 to 120. The offense of criminal conspiracy is dealt with under Chapter 5A, consisting of sections 120A and 120B, and rules pertaining to an attempt to commit an offense is provided in Chapter 23, consisting of one section, that is 511. All these preliminary or inchoate crimes are dealt with in a single chapter, that is Chapter 4 of the Sanhita. Chapter 4 of the Sanhita, containing sections 45 to 62, includes provisions pertaining to abetment, criminal conspiracy, and attempt. Sections 45 to 60 deal with abetment. Though the content of the provisions is the same, they have been reorganized in such a way that the conditions of liability are grouped together, and those that provide for punishment for successful and unsuccessful abetment are grouped together. Section 61 of the new code deals with criminal conspiracy, and Section 62 deals with attempt. The provisions in the Sanhita, along with the illustrations attached to the provisions, are exactly the same as contained in the Indian Penal Code. The special part of the Sanhita, consisting of specific offences, is contained from Chapter 5 to Chapter 19. The changes that are proposed to be brought in this part would be dealt with as and when those provisions are discussed. The Indian Penal Code came into force on 1st of January 1862. The provisions have been working effectively even in independent India. After the coming into force of the Constitution, any legal provision which is violative of any provision of the Constitution can be declared ultra vires. Various provisions of the Code have been tested for its constitutionality, and wherever a provision was found to be arbitrary, it was struck down by the Supreme Court. Unnecessary and inconsistent provisions have been repealed. With the changing needs, the Code has been amended from time to time. The new Act has consolidated and regrouped the provisions. Certain new offences have been introduced and the provisions pertaining to punishments have been upgraded, the details of which would be discussed while explaining the specific offences. Thank you.